We're on the record in cause number 323442, the state of Texas versus Eddie Wynn. Mr. Wynn, would you please come forward? Mr. Wynn, would you please raise your right hand? Mr. Wynn, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Mr. Wynn, you may put your hand down. How are you doing, Mr. Wynn? All right, that's good. Mr. Wynn, you're here represented by your attorney, Mr. Don Boudreaux. Your case is set, case is placed on our docket this morning. Mr. Wynn,
May I make a statement first?
okay,
Mr. Wynn was supposed to be here on the 7th of December of this year. There was a problem, and he had just started a new job up in California. And well, I was hoping that we could get it postponed for a bit. And he, for that reason, he didn't make it. He was having problems with his job, and he was not able to make it. We're very sorry about that, and we would ask the court to cancel out or allow him to not be found to be in violation of not being here in a timely manner. Do you have something to say to the judge about him?
I was traveling during the time I was dropping off a trailer, and I thought that he was going to send like a letter and ask you if we could postpone the court date instead of waiting to actually come before the day. And I apologize. I did not know that this could happen, and that's why I got that one.
okay. Well, I think you had brought that up before the court on the day that he did not appear.
Yes, sir.
But the court is not going to set aside the bond forfeiture. The bond forfeiture is still going to stay in place.
Okay, so that means he'll have a fine to pay on that?
Well, I don't know. You would have to, whenever that comes up, I can't talk to you about that, but the bond forfeiture, the bond that was forfeited is not being set aside. Okay? Now, again, we're on the record in cause number 323442, State of Texas versus Eddie Wynn. Mr. Wynn, you was just sworn in, is that correct?
Yes, sir.
Now, Mr. Wynn, the information before this court states that on or about April 7th of 2019, while you were in Jefferson County, Texas, you were charged with the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Wynn, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Wynn, how do you plead guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Wynn, I'm going to show you what's been marked as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, Mr. Wynn, are these your initials on line 2?
Yes, sir.
And on page 3 of this same document, Mr. Wynn, is that your signature above the line that says defendant?
Yes, sir.
On the next document, which is titled the Trial Court Certification of Defendant's Right of Appeal, Mr. Wynn, is that your signature at the bottom above the line that says defendant?
Yes, sir.
Now, there are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box says that you're waiving, which means you're giving up your right to appeal. Do you understand that? I have before me a document that is titled the Discovery Certification. Mr. Wynn, do you recognize this document? And is this your signature above the line that says defendant?
Yes, sir.
Now, prior to signing and initialing these documents, did your attorney, Mr. Boudreaux, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer States 1?
Yes, Your Honor.
Any objections?
No, sir.
Okay, no objections. States Exhibit number 1 will be admitted. State, will you be offering States Exhibit number 2?
Yes, Your Honor.
You have any objections?
No, sir.
Okay, no objection. States Exhibit number 2 will be admitted. States Exhibit number 2 is the probable cause affidavit. Mr. Boudreaux, you have advised and counseled Mr. Nguyen. Is there any evidence that he is currently mentally incompetent to stand trial?
No, sir.
Mr. Nguyen, your attorney, Mr. Boudreaux, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Nguyen, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that the plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
The state is offering 180 days probated over 15 months, a $500 fine plus court costs, 80 hours of community service, DWI standard plus interlock.
What was the, did you say it was for 16 months? I thought it was
15.
15, I'm sorry. And Judge, there's also, the state will not oppose an occupational license. And Mr. Nguyen has a trailer that he needs to move back to Florida, which was his original home, but he is living in Texas at the present time in and around Baytown. And it may be a short while before he gets his occupational driver's license. We would ask the court to perhaps delay the sentencing of this, or be not opposed to him taking his trailer back to Florida. And he will need an occupational license to be able to drive it back.
Well,
It may take me a little bit to get it done.
well, I mean, at this point, you know, he doesn't have a petition file for an occupational license, so the court cannot entertain that matter. And the other issue is whether giving him permission to do, court cannot give him permission to do that. But the third thing that you brought up is delaying the sentencing. So you're saying that you want to reset the sentencing? Is that what you're saying?
If I could, just so that I could get the occupational license filed, so that he would not be breaking any laws.
Okay, so Ms. Musgrove, did you hear that?
No, Your Honor.
Apparently, he wants to reset this case for, he doesn't want to enter the plea today. Well, he entered a plea, but he wants to
entered the
reset,
plea, but
he want to reset it for sentencing.
Okay.
it would only, Your Honor.
Okay, what date you like to reset your case for sentencing?
Probably about 30 days or less.
Okay, we have to get our coordinator to give you a date, so we're gonna, okay,
I'm
so
sorry, Judge.
you entered a plea, but we're not, the court has accepted the plea. Well, okay, let me do this here. Mr. Nguyen,
Yes, sir.
okay, you have entered a plea of no contest,
Yes, sir.
okay, to these charges. Now, the court is going to accept your plea of no contest and the waivers that you have filed. Now, let me do this. Let me do this here. Let me just back up a minute. Now, Mr. Nguyen,
Yes, sir.
I showed you what has been marked as State's Exhibit number 1, which was the misdemeanor plea admonishment.
Yes, sir.
And the court asked you, did you recognize this document? Is that correct?
Yes, sir.
And on page 2, you acknowledge that these were your
Yes, sir.
initials. And on page 3, you acknowledge that that's your signature above line 3.
Yes.
I mean, above the line that says defendant. And on the next document, which is trial court certification defendant's right of appeal, you acknowledge that that's your signature above the line that says defendant. And you understood that the first box says check states that this is a plea bargain case, you have no right of appeal, is that correct?
Yes, sir.
Second box says that you're waiving or giving up your right to the appeal, is that correct? You understood that? And the third document was the trial court certification of defendant's right of appeal.
Yes, sir.
And that is your signature on the line that says defendant. And you have acknowledged for the court that you have read, now, did your attorney go over these documents with you?
Yes. Yes, sir.
And did you read these documents?
Not word for word, but I take it from what he said.
Well, okay, let me do this here. Before we can go any further, you need to read those. That he's gonna have to read the documents. He go over the documents, and so we're gonna be in a recess. And I think what we may have to do is just, he has a warrant out, right? Simple, does he have a warrant out?
Yes, sir.
His bond was forfeited, okay. So, if he has a warrant out, he's gonna be taken into custody.
Oh.
If this plea is not,
No, I don't want that. I just
Well-
want to get this over with.
I mean, if we reset this case, that's what's gonna happen, because we're gonna execute that warrant.
No, not pretty sure, very, nominal bond be set and.
Well, I mean, this bond is gonna be reasonable. It's gonna be, we're gonna look at the facts and, pursuant to the, code of criminal procedure. I think it's 17.4.
Just get everything ordered today. I'll figure it out.
Okay, Judge,
Yes,
Mr. Wynn said we would withdraw that plea and he'll go ahead and just get everything done today.
so okay, so okay, well, you still, what we're gonna do, gonna be in recess, give you an opportunity to go over the paperwork with him.
Can I just ask a question, sir?
Well, you might wanna consult with your attorney before you ask, any questions. Consult with your attorney first. All right. Okay, we'll be in